Hi, I'm Gregory Vadas. I'm Chief of the Federal Communications Commission's Office of Intergovernmental Affairs. I'd like to welcome you to today's sixth webinar for state and local governments put on here by the FCC. We have a great program for you. For those of you who would like to register via WebEx, you could go to the FCC's event page and you could find the information on how to log on. We're accepting questions via live stream as well as Twitter and WebEx. And all the information, again, is on our event page. We are very lucky today to have Chairman Wheeler coming down to give a brief message to our partners in state and local government. And I'll quickly run through the rest of the agenda. We have speakers on E-rate and the IP transition, as well as the open internet ruling back in January. We'll also talk about wireless infrastructure issues, some issues which I know are of great importance to state and local governments, and positive train control briefly. And we'll also have a presenter from our Office of Engineering and Technology talking about a new app that we have here at the FCC that's free to everyone to allow state and local governments to measure their actual broadband speed. We'll hear a little bit about Next Generation 911 from our Public Safety Bureau. And finally, we're going to talk about the new closed captioning rules that just went into effect. So we really have a packed program that'll take us well through 4 o'clock. And I welcome you and thank you for joining us. And I encourage you to send questions again via Twitter, webmail, or FCC's live stream. And our presenters will take them after they're done speaking. Thank you. Somebody just passed me a note, and I think the chairman will be delayed a few minutes. So I think we're going to kick off the webinar with our first speaker, Charles Eberly from the Wireline Competition Bureau. He's a senior attorney in that bureau, and Charles is going to speak to us about modernizing the E-rate program, which I know is also one of the priorities for the chairman. Thank you, Charles. Let's do a quick switch. Thanks.
Good afternoon. So will this go up?
Yep.
All right. So thank you for the introduction. My name is as you mentioned, my name is Chaz Eberly. I'm an attorney in the Wireline Bureau on the E-rate team. And I've been asked today to give you a rundown of the E-rate modernization process as well as a general history of the E-rate program. I will keep this presentation pretty quick and at a pretty high level to allow time for questions from all those out there watching. So first and foremost, some basic background on the E-rate program. E-rate modernization is a top priority for both the chairman and the entire commission. This is a program that has been very successful over 15 plus years and helped pay for school and library phone service, internet access, and several other supported services. Last year, we on the E-rate team undertook a comprehensive modernization of the program to focus on high-speed broadband because we understand that schools and libraries need high-speed connectivity now to benefit from digital learning, and that this need will only increase in the future. So first, let's go over some basics of the E-rate program, more formally known as the Schools and Libraries Universal Support Mechanism. The program was authorized by the Telecommunications Act of 1996, created by the Commission in 1997, and the first funding year was 1998. The program is administered by the Universal Service Administrative Company, commonly known as USAC. Schools and libraries apply for discounts based on services that fall into two priorities. Discounts are based on the school or library's level of poverty and whether the population served is urban or rural. Priority 1 services, as we refer to them, include telecommunications services, and internet access. Priority 2 includes internal connections, effectively Wi-Fi and the components related to delivering Wi-Fi. as well as basic maintenance of internal connections and several other services. Total E-rate funding is capped and indexed to inflation. The current cap for funding year 2014 is $2.41 billion. Demand every year exceeds the cap, one of the reasons for our modernization process. All right. As I mentioned, in July of 2013, the Commission undertook modernizing the E-rate program by releasing a Notice of Proposed Rulemaking. That NPRM sought to comment on three key goals to modernize the program. First and foremost, ensuring affordable access to 21st century broadband that supports digital learning. This is broadband delivered both to the building and within the building. The second goal of modernization, maximizing cost effectiveness, by which we mean stretching every dollar as far as we can go to get the best value for E-rate funds. Third, streamlining the administration of the program. Our goal here is to make the program easier and more productive for applicants. Over the last several months, we have been reviewing comments, meeting with stakeholders, and analyzing voluminous data with an eye towards an order early summer. The next step in the modernization process was a public notice released in March of 2014. This public notice sought additional comment to supplement and focus our record. The public notice focused on a few specific topics, three major topics actually. First and foremost, focusing E-rate on high-speed broadband both to and within the school and library. This, of course, has two elements. First, an emphasis on internal connections, what I referred to earlier as Priority 2 services. This is part of our recognition that E-rate must support connectivity both to and within the building, and historically, the bulk of E-rate funds have gone to connections to the school or library due to the fact that the majority funding requests are Priority 1, and Priority 1 services are funded, all Priority 1 services, are funded before Priority 2. However, we recognize that the future will require robust Wi-Fi and wireless local area networks in schools and libraries, and therefore the E-rate program must adjust to bring substantial focus to internal connections. The second major part of focusing the program on broadband connectivity is seeking comment on establishing one-time support for those schools and libraries that do not currently have high-speed broadband connectivity. Two other major issues raised in the public notice were phasing out or reducing support for traditional voice services and seeking comment and proposals for demonstration projects that can show cost-effective ways to deliver high-speed connectivity to schools and libraries. These are just three of many important issues under consideration in our rulemaking. The PN does not, of course, represent the full set of issues under consideration. Many of the topics initially raised in the Notice of Proposed Rulemaking remain under consideration. The next point I wanted to cover was the role of state and local governments in our E-rate rulemaking. I've worked extensively on outreach to state, local, and school district officials to better understand purchasing models, cost-effective purchasing, and gather data. This has included phone calls and meetings with research and education network staff, library staff, school district staff, and State Department of Ed and technology purchasing staff. And we have a very high focus on data collection and data analysis in this rulemaking. It's important for the E-rate team to better understand the current connectivity and prices being paid by schools and libraries, as well as to model the costs of improving that connectivity and deploying high-quality Wi-Fi to schools and libraries across the country. We urge state and local officials that have data, since we have not spoken to everyone, to contact the E-rate team and share that data. This data analysis will continue to play an important role in our modernization. To conclude, briefly, we are moving full speed ahead with E-rate modernization. As you will no doubt soon hear, Chairman Wheeler is committed to modernizing the program for the benefit of students and communities. We have a lot of work to do, and we need your help. I'd like to thank the U.S. Conference of Mayors and National Association of Counties for their support, and we welcome constructive suggestions and feedback, continued data, and any additional support you may provide to make the E-rate program the best it can be. And with that.
Okay. Thank you, Charles. You know what? We're going to hold our questions for Charles until after the chairman speaks. We're very lucky today to have this is our 6th webinar, and I know this is the first time we've had a FCC chairman come down to speak to our state and local governments directly, so I think that says a lot about this chairman's priority. And without further ado, I give you the chairman of the FCC, Mr. Tom Wheeler.
Thank you, Gregory.
Thank you, sir.
And I want to commend you for your wise judgment in moving forward and not waiting for me to show up and not wasting these people's time. It's great to be here, and I'm going to be very brief because really what you want to be doing is talking to Charles and the others about the kinds of things that we're working on here. But we recognize that this is an activity that we share jointly, a responsibility that we all have to deal with the incredible change that is going on in technology and how it's impacting our networks and therefore impacting the consumers that we all represent. I thought it might just make some sense. I've got the program here. I thought it might make some sense to real quickly just go through a couple of things and just look at the program. Charles was just talking about the E-rate program. He was absolutely spot on when he made some reference to the fact that Chairman Wheeler is dedicated to the modernization of the E-rate program. There couldn't be a truer statement. This is a great time that we have to take a look at a program which for the last 18 years has been absolutely seminal in connecting schools and libraries, and now say, how do we move it from a 20th century program of 20th century services to a 21st century program? And I sat through some of what Charles was presenting to you, and know that you'll have interesting questions for him. One of the other things, Matt Del Nero is going to be talking after that about the IP transition. We don't have to tell you about what's going on in terms of everything going from circuit switch to Internet protocol. But the question is, how do we maintain in that kind of a transition the values that have traditionally represented the relationship between those who use network services and those who build and operate networks. We started calling this the Network Compact, and we think there are 5. Access, interconnection, consumer protection, public safety, and national security. And the question is, how do we port those over, to use an IP term? How do we port those values over from the TDM world to an IP world? That's an exciting prospect. That's a challenging prospect. That's a prospect that we will be testing in trials over time. And then addressing in terms of how do we port one to the other. Then the Open Internet rules. I understand you're going to be discussing the Open Internet rules. We are strongly pro Open Internet. We believe that the headlines that were probably in most of your papers after the D.C. Circuit's decision in which they announced the FCC had lost and that Open Internet was imperiled were wrong. The Verizon went to court to try and have the court say the FCC did not have jurisdiction over the Open Internet, and the court said au contraire and told us how to exercise that jurisdiction. I have said repeatedly that I consider the court decision to be an invitation to act, and that I intend to accept that invitation. So in the next couple of months, we will be bringing forward a new notice on how we can deliver on the promise of the Open Internet, following the roadmap that the court gave us. Then I see wireless infrastructure issues, facilities, siting rulemaking, positive train control. It's just really basic that if we're going to have the kind of competition that protects consumers, promotes innovation, and drives lower prices, that we have to have the facilities out there that will deliver that competition. Those facilities should not be impeded in their rollout. It's interesting that Google and now AT&T and others are saying that we will build broadband networks in those places which are most hospitable to us. That's something we all have to consider, and we all have to deal with the fullness of those ramifications if we truly believe in competition and truly believe in innovative next generation services. You're going to talk about the FCC Speed Test app. We're really proud about that. The folks here have done a tremendous job on that. Crowdsourcing information. One of the great things about the new network is the network can actually report on itself, and we intend to use that both in a wired and a wireless context. Next generation 911. As we go to a increasingly wireless reality, we have to make sure that people's safety is protected, and that the right and then the expectation that which is a right that you can access emergency services is fulfilled. We've started down that road in many areas having to do with text to 911, location accuracy of wireless 911 calls, and we'll continue heading down that path. And then finally, the last item, I see that Karen Pell-Strauss is going to be talking about closed captioning. We believe very strongly that it is not just broadband that is important, but broadband and all networks are important by not the fact that they just exist, but by what they enable and what they deliver. And this is why E-rate is so important. If we're not delivering a 21st century education to our students, shame on us. And on the same point, if we're not making sure that those for whom there are special challenges have access to the broadband capability and have opportunities to use that broadband capability to address some of their challenges, then shame on us as well. And so one of the things that we did early on here was to dust off a 10-year-old petition on improving the quality of closed captioning, and Karen Pell-Strauss is going to visit with you more about that. I've already talked past my 5 minutes, nothing like arriving late and talking too long. But I do appreciate the opportunity to be here, and the fact that all of you are participating out there. And I'll turn it back over now to the people who are really doing the work. Thank you.
Thank you, Mr. Chairman. We appreciate your time. Thank you. Okay. Next up will be Matthew Del Nero. He's Deputy Bureau Chief in the Wireline Competition Bureau, and he'll be talking about the IP transition. I know we'll probably have a lot of questions on that with the trials taking place. And I should also mention that we'll hold any questions for Charles on E-rate until after Matt's done, and then we'll take questions on both topics. So without further ado, I give you Matthew Del Nero.
Thank you very much, Matt. Set up here.
Be able to get to the full screen.
Slideshow. Okay. Thank you very much for having me. Thanks for the introduction. I'm going to be focusing today on technology transitions. We sometimes refer to it as IP transition, although that's really a shorthand for a broader set of transitions that are happening. and that, as Chairman Wheeler mentioned, the Commission is very focused on. I just joined the Commission myself a couple months ago, and it's have been reflecting upon what an exciting time it is to be here at the FCC working on issues related to tech transitions, because they're going to have such an enormous impact on the American public at the local, state, and national level for a long time to come. So with that, if we can go to the slides here, what I'll be focusing on in the presentation are particular actions the Commission in January set in motion to learn about the impact of technology transitions on consumers and on the network values that the Chairman mentioned. But I think it helps, before jumping into that, to take a step back and to talk about what we mean when we talk about tech transitions. So the statistics here on this slide, I think, speak a great deal to the fact that we do have a very changing communications landscape. You see, retail switched access lines, your traditional POTS, having a combined annual decline since 2009 of 9%. Interconnected VoIP, on the other hand, both that offered by the LECs and by cable companies and by over-the-top providers, up quite a great deal, 17% each year. And then, of course, mobile subscriptions continuing to grow at a rate of 4% per year, even in what is a very mature market. And then the statistic that about 40% of households are wireless only. So it's a very different market than it was just 10 years ago. We think of these technology transitions really in three different layers. And that's, again, one reason that we say it's technology transitions in the plural. You have the physical layer changes, that's really at the bottom here of the slide, of going from the infrastructure primarily being copper twisted pair over to a multitude of types of infrastructure, including fiber, wireless, still does include copper twisted pair, coax, and various combinations of these. So copper no longer being the principal means of infrastructure at the physical layer. At the transport layer, as we would call it, what once used to be primarily TDM-based circuits for carrying both voice and data is transitioning over to IP-based packets, and hence the IP transition. And then at the application layer, what once was focused primarily on TDM-based voice is now moving over to, for voice, obviously VoIP and other applications that are riding on these networks. So TDM voice no longer being the principal application. There's clearly tremendous potential benefits of these transitions, and we welcome the transitions. We're very happy to see them. Just to name a few, billions of dollars of investment in infrastructure by providers that powers economic growth. We see benefits for public safety, for example. The chairman mentioned Next Generation 911, and you can imagine some of the, for example, multimedia capabilities in terms of texting, data, photos, videos that would go to emergency responders in very efficient ways. And then just to cite another example, new forms of disabilities access. As the chairman mentioned, this isn't just about networks, it's about what the networks make available, what they make possible. And there are tremendous possibilities for IP technology to improve services for Americans who are deaf, deafblind, or hard of hearing, or otherwise disabled. And you'll be hearing in particular about that from my colleague Karen Peltz-Strauss later today. So there's clearly tremendous benefits, and I always want to begin with those benefits when I talk about the IP transition, so that we're not simply talking about it as something that is a challenge. But there are challenges to technology transitions. To date, these really have been happening organically and in parallel with the availability of legacy services, and particularly the legacy POTS service. So that legacy service has always been available. You've essentially had parallel networks. But as these transitions progress, you reach a point when, for example, providers will seek to, for economic reasons, discontinue the legacy services, finding that at a certain point it's no longer economically efficient to maintain both the legacy network and the IP-based network. And it's at that point, as often is said, that the legacy service has reached a tipping point. That means, as the Commission noted in January, that at a certain point a choice is removed from the marketplace that had been there for the customers who depended on it. So it's not necessarily then a voluntary migration to a new network. It's, for some customers, an involuntary migration. And the question there is, how do we manage that transition that is happening, that inevitable transition, in a way that preserves the fundamental values that the chairman mentioned? And we refer to that as the Network Compact. I think these are well known, certainly to states and local governmental entities. Universal access is something that was an overarching policy objective achieved in the POTS network, and something that we very much do not want to see, a value that we do not want to see go away in an IP-based world. Public safety, and I should have noted national security there, being tremendously important. As I think the chairman said in one of his speeches, it's not clear that folks would be too excited about a network where you can't reach 911. Competition. This agency has had competition as a mandate since its founding, and has worked hard, particularly in recent decades, to foster competition. We do not want to see competition lost in this transition. We want to see it fostered and even enhanced. And then consumer protection. At the end of the day, our job is to serve the American public. And as these transitions going on, and we think about our role and what steps we should take, first and foremost in our mind is the American consumer. So with that backdrop, I'll transition, no pun intended, over to the specific steps the Commission took in its January order. And that order was really focused on conducting experiments and collecting data to understand how consumers are affected by these technology transitions. The notion being that it's essential for the Commission to have good data and good information on which it bases its decision-making related to tech transitions. I won't go through each and every one of them. We wouldn't have time here today. I'll spend most of my time on service-based experiments and rural broadband experiments. But I should also mention that the order set in motion an ambitious project related to research and development on IP-based services for persons with disabilities. Set in motion a numbering test bed being led by our Chief Technology Officer, Henning Schulzrinne, which has already been kicked off, that is designed to look at the future of numbering in an all IP-based world. And this test bed enables a kind of sandbox for looking at new ways of looking at how numbering works in the IP-based world without disrupting the existing numbering databases that are still very much in use. Fifth, an ongoing data initiative, one of the hallmarks of that being a consumer data initiative, which my colleagues in Consumer and Governmental Affairs Bureau are working very hard on, along with partners in states and localities, to determine how best we gather information about how the technology transitions are affecting consumers. So, for example, best practices related to consumer complaints that arise from the transition. Say a customer that is being moved from a copper network to a fiber network and has a concern about what that means for backup power on their availability of phone service in the event of a power outage. How do you best make sure that we're capturing data about that, and that consumer is well educated and knows how to reach out to consumer protection authorities, including the Commission. And then sixth is information about how the IP transition is affecting public safety and national security. And I wanted to mention on that my colleagues in the Public Safety Bureau, led by Admiral Simpson, the head of the Public Safety and Homeland Security Bureau, recently held a workshop just last week that looked at that. And as the Admiral noted, as networks transform, the capability for public safety officials to reliably communicate among themselves and with the public must be preserved. And the availability of individuals to reach help in an emergency is fundamental and must be maintained. So that workshop looked both at how do you ensure that critical functionalities served by the legacy infrastructure are supported in the new networks, but also at how we can leverage the new networks to do even better and have even better public safety communications and stronger national security. And then I want to mention also that Chairman Wheeler announced in his statement to the January order that he will be releasing what we call a managerial framework. Most of the January order is really focused on, as I said, data gathering, experiments, information. But we recognize that there are important policy decisions to be made in regards to the technology transitions. And some of those policy decisions will need to be made in the relatively near term. And so this managerial framework will set forth essentially a strategy, a plan for how, not necessarily what the answers will be to all of those policy questions, but which policy questions and kind of in what order we would be addressing them. So that will be coming out later this spring, and I'd encourage you all to take a look at it when it's available, because we don't want to lose sight of the important policy questions to be resolved. But going on to, as I said, I would focus on the service-based experiments, which I know is a lot of interest to state and local governments. That order, in response to petitions from AT&T, had invited providers to propose what we call service-based experiments. And providers are allowed to propose these at any point on a rolling basis during a 12-month period. So the window is still open for that. And these are, as we say, experiments in which the providers would substitute new technology for the TDM-based services that are out there now. They're meant to be impact experiments. They're not intended, and the Commission was very clear on this, these are not experiments to say, where at the end you will come out and say, okay, the answer to this legal or policy question is X, Y, or Z. They're not intended to resolve legal or policy debates. And they're not really intended to test technology per se. They're really more about testing what does it mean for consumers when you move from a TDM-based network to an IP-based network. And we set forth to be sure that these experiments are conducted in a way that doesn't create any harm to consumers or the other network values while they're being conducted. We set forth a number of conditions and presumptions that we would expect applicants to meet. So just for example, a condition would be you have to preserve 911 and E911 access in any experiment. Presumption would be there would be no decrease in broadband access as a result of an experiment. We also set forth things like customer notices and what would have to be in those, and the sort of data collection and submission we'd like to see. AT&T has submitted, and I think this has been the highest profile item on service-based experiments. AT&T has submitted a proposal where it would trial the IP transition, essentially moving eventually all customers in a wire center off of POTS service and onto either wireline IP or a wireless service in Carbon Hill, Alabama, and Kings Point, Florida, also known as West Delray Beach. And I realize that in these two pictures, I think they're not to scale. I have made Alabama significantly larger than Florida. So in case anyone from Florida is watching, I know I got the scale off there. But the transitions they would propose, as I mentioned, is for customers that are on POTS, some would have the option of going to UVerse. That would be for voice, the interconnected VoIP product that run over UVerse, and the high-speed internet product on that all IP-based network. Some customers would have the option of moving to something called wireless home phone, which would be an entirely wireless product offered by AT&T Mobility, which AT&T categorizes or describes as a CMRS product that would offer voice and then 4G LTE broadband. And some of those customers would have access to both. Either they could go to UVerse or wireless home phone. Some would have access only to the wireless home phone product. And then there is a third other category, which AT&T explains that under its trial proposal, 4% of the living units in Carbon Hill would be served by some other product or service or provider. And AT&T acknowledges that that it has the obligation to come up with an acceptable substitute for the AT&T POTS service for those 4% of consumers, and has committed to file in the future an explanation of what that product would be. It also proposes to act in certain phases. We're in what AT&T calls phase 0 right now. That began with the filing of the proposal, and it involves essentially initial outreach. If you're in one of the two wire centers, you probably are aware there's been outreach to governmental officials. There's been different kind of town hall meetings. There are some microsites where people can get more information. I think notices have gone out to customers. But there's been no discontinuance of service in phase 0. And in fact, AT&T has yet to seek any discontinuance of service from the Commission. In phase 1, there would be grandfathering of existing retail accounts, meaning if you have POTS service, you can keep it, but let's say you move to Kings Point and go to get POTS service, it wouldn't be available to you at that point. You would have either the UVerse option and or the wireless home phone option. That would have to be preceded under our rules, and as we've made clear and AT&T has acknowledged, preceded by Section 214A discontinuance applications, which would involve its own public process and comment period. And then the second phase would be sunsetting of existing retail accounts, where someone who, say, is currently on POTS service, has been on it for a long time, would be migrated over to either the wireless home phone or the UVerse option. And that, too, as we've made clear in the order, would be preceded by another set of Section 214 applications and associated public processing and comment opportunity. AT&T has also signaled that it intends to would like to conduct an additional phase involving wholesale products rather than just the retail products and services. And this, too, would require further filings by AT&T and provide additional opportunity for public comment. In terms of our own process, as some of you may know, we quickly sought comment on AT&T's proposal. We received comments on March 31st. They ranged, there were about 30 or so comments. They ranged from some supportive to some concerned. And on the concerned category, I would say there's a focus on the wholesale piece of things, a lot of concern among CLECs regarding what the wholesale piece of the trial will look like, since that hasn't been quite fully formed. Parties concerned about the consumers who had moved to a wireless-only product, and parties concerned about data collection. Also some questions about, are the specific wire centers representative or not? We're looking at those concerns seriously, and we're continuing to solicit input from the public in the open docket. We've also received reply comments on April 10. We did meet with AT&T on March 21st to ask some of our own questions about the proposal, and AT&T filed a detailed ex parte. You can see that lays out some of the answers to our questions. There's also pending, filed by Public Knowledge and Consumer Law Center, a petition to have some of the information in the AT&T proposal unredacted, meaning it wouldn't be subject to a protective order that limits the access of some of the information in the filing, and we're looking at that very seriously as well. I also wanted to talk briefly about the rural broadband experiments that were set in motion by the January order. In January, the Commission authorized experiments that will use funding from the essentially unallocated funding from the Connect America Fund, with a key objective of determining whether there's interest in deploying robust, scalable networks for an amount equal or less than our model-based predicted support in areas not presently served by broadband. And here we're talking about areas not presently served with at least 3 megabits per second downstream and 768 kilobits per second upstream. We have received over 1,000 expressions of interest in that funding. It's a very geographically diverse group. We're very happy with the level of interest. It includes ILECs, CLECs, electric co-ops, WISPs, governmental entities, and cable operators. Our next step there is to review that record, to digest it, and then the Commission itself at some point will adopt a budget and criteria for formal applications, so something a little more detailed than the expressions of interest that we asked for in this first round. We then would solicit those formal project proposals, and the FCC expects to select a small number of projects later in 2014 for funding. And I've included in there the list, the website for the Rural Broadband Experiments webpage. I think one of the important things about those experiments is it's more, although one of the benefits may be that in those areas that are funded, it promotes broadband deployment, but it's also going to provide very important information to the Commission that will help inform future decision making related to our CAF policies as we look forward on the continued transformation of our universal service programs. With that, I would just mention that state and local governments are our partners in this tech transitions efforts. We welcome your input. We're excited to get your input. Some entities have already commented on the AT&T proposal, which we appreciated. I would mention just the Pennsylvania PUC, the Alabama PSC, Texas 911 entities, among others. And we would encourage you to continue to please be in touch with us with your thoughts, questions, concerns, whether it's about the specifics of things like the AT&T proposal or more broadly about policy priorities and objectives related to tech transitions. As I say, at the end of the day, our ultimate goal is to ensure that the network compact, those four key values that we mentioned, are preserved into the future at the same time that Americans have the benefit of the innovation made possible by new IP-based networks. And with that, I think we can move over into questions both about E-rate and about tech transition.
Thank you very much, Matt. That was extremely informative. We have a pretty engaged audience today, and we'll continue with you on questions about the IP transition. And the first one concerns the IP transition and the historic value telecommunication networks have been it concerns franchise fees to local governments and the rights of municipal rights of way, and they're wondering the question is wondering what's going to happen to franchise when municipalities still receive franchise fees for internet-based services, concerning the payment of franchise fees on an IP network.
Yeah, the franchise fees and I may have to look a little further into that, but the franchise fees with which I'm most familiar are for rights of way, including, for example, you take cable television, right, the standard 5% that most municipalities get. I'm not aware of anything that is going to, in the IP transition, that's necessarily changing that, but I think it's perhaps I'm wondering if the question's perhaps broader than that.
Well, I guess it's asking, and this might be too broad for us, what is the view of FCC concerning payment of franchise fees as the industry transitions to IP networks? So it was specific and broad. And it's my understanding is you're the local franchise authority. Some are statewide, some are county-wide, some are municipal-wide, and it's still within the jurisdiction's purview to collect franchise fees.
For local, yeah, I'm not aware of any situations where, in relation to IP transition, there's been those haven't come to us. Let's say issues of franchise fees not being, parties not able to assess them. But I think if the questioner has maybe a specific circumstance in mind, I would encourage the questioner maybe to get in touch with us, because it sounds like there might be a specific instance that we could provide a little bit more guidance on.
You could certainly send this to myself, gregory.vatis@fcc.gov, or give me a call, and we'll work with Matt and his team to answer your specific question. Yeah. But whether it's a state who has the franchise authority, the county, the city, it's still your franchise authority again, as I understand it. Let me see, we have one more maybe coming in. I think we have a question from Public Utilities Commissioner in the state of South Dakota, and he says, Mr. Chris Nelson, today is the first I've heard of the inclusion of national security as one of the enduring values. What drove the addition of that value? Thanks. I could take a quick stab at it. I think the chairman probably covered it under public safety. Yes. National security is a part of public safety, but I'll let
I think that's right. I think we've been using public safety as a shorthand, but when we, and if you look at the January order, we also consider, when we talk about public safety and the enduring values that need to be preserved, we also refer to security. So.
Okay, that's it. And I just let me just chime in on a housekeeping point of order. The PowerPoints will be up either later today or tomorrow on the FCC event page for this event, so you guys will be able to view them later. So thanks for all the questions about that. I think we had a few questions for Charles as well. Let me on E-rate, and the first one is, does the FCC anticipate that Priority 2 E-rate funding request will be funded for the current year, 2014-2015?
Well, for funding year 2013, you may or may not know, USAC announced in February that no Priority 2 applications would be funded, again, for funding year 2013. The funding year 2014 window just closed at the end of March, and USAC is currently reviewing applications. No decisions have been made on those applications, but clearly, as we discussed and as you know well, demand is very high, likely to exceed the cap. So no decisions have been made for funding year 2014, but it was announced a couple months ago that no P2 would be funded in funding year 2013.
Great, thanks. We have one more from our tribal constituency. It says, Charles mentioned the role of state, local, and school government. However, there do not appear to be substantial reporting mechanisms in place to determine the E-rate penetrations for tribal schools and libraries. What efforts have been made to determine the service and priority of E-rate to tribes, tribal, and BIE schools or areas that serve large populations of Native Americans and Alaska Native students?
Sure. I can answer that briefly. Tribal schools and libraries have definitely been part of our data outreach. Like all schools and libraries nationwide, we have some good data, but far from comprehensive data on both the level of connectivity on tribal lands and the cost of connectivity on tribal lands. So I would urge anyone out there with good data on those factors to get in touch with us and provide that data for our record, because tribal communities, just like really all school and library communities across the country, we're trying to gather up all the data we can to fully understand the lay of the land.
Great. Unless there are any more questions for Matt or Charles, I think I think we'll take those and we'll get back to you offline on any further questions. Feel free to send them in, and we'll answer them offline. And in the interest of keeping our webinar on time, I'm going to introduce our next speaker. And thank you both so much for your time and expertise. We really appreciate it.
very much.
Thank you so much. Thank you, Charles. Okay. Great. Next up is Stephanie Weiner. She's an Associate General Counsel in the FCC's Office of General Counsel, and she's going to be speaking about our open internet rules and the D.C. Circuit Court's opinion that came down in January, and how we are going to proceed. So thank you, Stephanie. We really appreciate this, and I know this has been a matter of interest to a lot of folks in state and local government to hear what it means for us. And, thank you.
Of course. Thank you, Greg. And thank you. Good afternoon. Oh, thank you. So as Greg mentioned, I'm going to speak about the open internet proceeding. And I thought that we would talk about a little background first, just sort of how we got here, where we are today, and then talk about where we're going. The Commission, of course, has taken actions to safeguard internet openness for over a decade. But most recently, the Commission adopted the Open Internet Order in December 2010, and that really is our starting point for my presentation today. As is known, Verizon challenged those rules in the D.C. Circuit, and as Greg mentioned, the D.C. Circuit issued a decision in January of this year. Before we talk about that decision, I wanted to go back and think a little bit and discuss a little bit the rules that were adopted in the 2010 order. In essence, the Commission adopted three main rules. The first had to do with transparency, and this was to ensure that all providers publicly disclose information about network management practices and commercial terms of service. And this disclosure was important for a number of reasons. Our objectives had to do with both disclosures to end users, empowering consumer choice, as well as to edge providers, those entities who operate on the edge of the network providing content and services over the Internet, for whom accurate information about broadband providers' network practices is essential to their business planning and assessment of risks. The second of the rules the Commission adopted we'll refer to as the no blocking rule. And we adopted a different rule for fixed broadband providers than for mobile providers. For fixed providers, the rule prohibited broadband providers, and that's providers of broadband internet access service, from blocking lawful content, applications, services, or non-harmful devices subject to reasonable network management. For mobile providers, as I said, the rule was a bit different. The Commission held that mobile providers shall not block lawful websites or block applications that compete with the provider's voice or video telephony services, subject to reasonable network management again. The last of the three rules that the Commission adopted was a prohibition on unreasonable discrimination. This rule stated that fixed providers shall not unreasonably discriminate in transmitting lawful network traffic over a consumer's broadband internet access service, subject, again, to reasonable network management. Importantly, this rule was not applied to mobile providers. It only applied to fixed providers of broadband internet access service. For all of these rules, the Commission looked to an overarching rationale. This was that the Internet and the end-to-end open architecture of the Internet created a virtuous circle in which innovations by those edge providers at the edges of the network led to increased demand for broadband by end users, by consumers, and that led to increased broadband investment and deployment. The Commission relied on a number of sources of authority for the 2010 rules, but most particularly on Section 706A and B of the Communications Act. Turning to the court decision, I want to go over it quickly and then I'll drill down a bit more. The court upheld the Commission's authority to promulgate open internet rules under Section 706. It also upheld the transparency rule. However, the court vacated and remanded the Commission's blocking and discrimination rules, finding that the Commission had selected the wrong mechanism to pursue its legitimate Section 706 objectives. I want to focus on authority for a minute because this was a significant holding from the D.C. Circuit. Specifically, the Court held that Section 706 is an independent grant of the Commission's authority. The Court recognized the importance of ensuring that EDGE providers can reach the people who use the Internet. Again, EDGE providers, those who use the network to deliver the goods and services such as video. The Court also held that the Commission had rightly identified the harms of the threats to Internet openness fell within the scope of the Commission's authority under Section 706. Specifically, it upheld the Commission's judgment that Internet openness encourages innovation and broadband investment, and that its absence could ultimately inhibit broadband deployment. With respect to the rules, there was a lot of discussion in the Court's opinion about the common carriage requirement, or about whether the rules were in fact common carriage regulations. The Court held that the Commission had selected, as I said before, the wrong mechanism in order to pursue its legitimate goals under Section 706 with respect to the no blocking and non-discrimination rules. In particular, it determined that those rules regulated broadband providers as common carriers, which the Commission could not do because the Commission has classified broadband Internet access service as an information service. And the Act prohibits the regulation of information service providers as common carriers. At the same time, though the Court vacated these rules, the opinion was careful to explain the kind of approach that the Commission could consider consistent with its Section 706 authority, and emphasized that it had upheld the Commission's wireless data roaming rules in the Selco case just a few months earlier. In light of the Court's opinion, the Commission is now on a path that was set forth by the Chairman in his announcement in February. And I want to talk a little bit about the steps that we're taking in the way forward. As I just mentioned, the Court sent the case back to the Commission with what Chairman Wheeler read as an invitation to act. And in his statement and announcements in February, the Chairman accepted that invitation. The Commission made the decision to forego further judicial review in light of the fact that the Commission had authority to issue its new rules under Section 706 and the ongoing availability of Title II. On February 19th, the Wireline Bureau released a public notice soliciting comment on the Verizon decision, on the Court's decision, and how the Commission should move forward on remand. And since then, the Chairman has also directed the staff to begin a rulemaking, which is now in the preliminary stages. And the direction he gave was that we should seek to enforce and enhance the existing transparency rule, which of course was not struck down by the Court, to fulfill the no blocking goals of the 2010 order, and also to fulfill the goals of the non-discrimination rule, consistent with the Court's guidance. On that rule, we are looking closely to the Court's decision as a bit of a blueprint for how to move forward. In particular, we're looking at our data roaming rules and the concept of adopting an enforceable legal standard that would provide some certainty for broadband provider practices, as well as articulating factors that would provide additional guidance towards the kind of practices that would satisfy that standard. And finally, a case-by-case approach to encourage individualized negotiations and, where necessary, enforcement based on the totality of the circumstances. We are working towards a notice of proposed rulemaking along these lines, which is expected to come out late spring, early summer, and the docket that was initially opened with the PNs listening comments on the remand remains open. So last, I just wanted to mention that we really thank you to those who may be on the phone who have submitted comments into the docket, and we welcome further input.
Thank you so much. Now's the time to ask questions. And I would also I'd also encourage our state and local government folks out there to take a look at the chairman's February 19th blog. He specifically addresses the case and sets forward the path that Stephanie did in greater detail here, but sort of a higher level. And we're glad we had Stephanie to fill in the lines for us today. But go ahead and...
I actually have a couple pages of resources that perhaps, Greg, I could provide to you, and then you could...
That'd be great.
Pass out to the group.
Well, yeah, you know what? We could get that. Thank you, Stephanie.
Sure,
we could get that up on the event page today or tomorrow, along with all the other PowerPoints. And I think that would be a lot of help to folks out there.
Sure.
But again, take a look at the February 19th blog. If you have any questions, I don't see any coming in, but if you think of them later on, you could send them to myself or to the live stream, and we'll get them to our speakers today and get back to you.
Of course.
Thank you so much for your time and expertise.
Sure.
Okay. Thanks, Stephanie. Great. Next up, we're going to talk about, next topic is wireless infrastructure issues. We're going to talk about the facility siting rulemaking. This is ongoing rulemaking that I know all our folks in state and local government have been active out there in. And Jeffrey Steinberg, Deputy Chief in the Wireless Telecommunications Bureau Spectrum and Competition Policy Division, will be speaking to you today about the wireless facilities rulemaking. I know we've already had some questions come in via Twitter. Jeff, you're going to start? Did I have that?
Yeah, I'm starting with
okay,
the
great.
PTC side, actually.
Oh, I'm sorry. I apologize. So, how do you guys want to start with? Do you want to start with positive train
I think
control?
so. Just get it out.
Okay. So we have a big chunk of time kind of allocated for both of these topics, but we're going to the majority of it's going to go to the wireless facilities rulemaking, and Peter's going to start with positive train control.
No.
Jeff's going to start with positive train control. I apologize. Wait, stop, reverse that.
Sorry about that. Okay. All right. Thanks, Greg. I'm Jeffrey Steinberg, Deputy Chief of the Spectrum and Competition Policy Division, and I know you're eager to move on to the infrastructure rulemaking proceeding, but I just wanted to give you a very brief update on positive train control, which is a big matter that we've been working on, largely in terms of our review under the environmental rules. Just quickly, by way of background, for those who either need a refresher or for whom this is new, positive train control is a technology intended to prevent certain types of train accidents that are due to human error by overriding the controls on the train. The railroads are mandated by statute to put this into place over most tracks that carry either passengers or poison by inhalation hazards by December 31st, 2015. The method that the railroads are using to implement positive train control, or PTC, involves the constructing over 20,000 poles along the railroad tracks nationwide, typically poles up to about 65 feet in height, spaced roughly every 1 to 3 miles along the railroad track. Because the PTC uses spectrum that is licensed by the FCC, the installation of these poles triggers the FCC's obligations under federal environmental statutes, including NEPA and the National Historic Preservation Act. Since the railroads first made us aware about a year ago of the scope of the construction that would be needed, we've been working hard at the FCC to come up with a review process that both satisfies the purposes of the environmental statutes and also will enable the railroads to meet their statutory mandate. And in addition, that also addresses the substantial numbers of poles that the railroads have already put up without going through the required review. The most challenging aspect of this is the review under Section 106 of the National Historic Preservation Act. We've consulted with the Advisory Council on Historic Preservation, which is the agency responsible for overseeing government-wide implementation of Section 106, and determined that the best thing to do was to ask ACHP to issue a program comment, which is a mechanism that's provided for in the ACHP rules to allow for departures from the typical method of Section 106 review. In developing the draft program comment, we've worked closely with state historic preservation officers and with tribal nations, and we also sought the input of local governments through their nationwide organizations. The current status of this: on March 4th, the FCC submitted a draft program comment to the ACHP for their review. Under the ACHP's rules, they were to have acted on that within 45 days, which would have expired last Friday. However, we recently granted an extension of the deadline until May 16th. So at this point, the FCC, our staff is working closely with ACHP on revisions to the draft program comment, but the process at this point is within ACHP's control. We expect that ACHP will be distributing a new draft to the stakeholders soon.
Okay, thanks, Jeff. Any questions? Please share them now. And positive train control is certainly something that's extremely important, as we saw by that accident a few months ago along the Harlem River in New York. Right. Trains are going through all your jurisdictions all the time, and when an accident happens, we need it, or before the accident happens, I should say, to prevent it, and that's the point of this. So.
All right, if I could just have another 30 seconds
Absolutely.
To put in a plug. For those who may be interested, on June 24th and 25th, the Wireless Bureau is sponsoring a couple of workshops on our environmental historic preservation review process. The one on June 24th is a sort of nuts and bolts issues that arise in the process generally. The second day, on the 25th, is directed specifically towards PTC. These are, I guess, intended in the first instances for our licensees and their consultants, but they can be of interest to other stakeholders in the process, including state, local, tribal government officials. Both days will be webcast live. For more information on how to register, we put out a public notice last week. It's DA 14-504. There's also an earlier PN, DA 14-382, which has a little more information on the content.
Okay. Thank you very much, Jeff. Appreciate your time. I'm so used to talking to you about the wireless facilities rulemaking, but today we have Peter covering the topic. Thanks, Peter. Really, just really want to thank the Wireless Telecommunications Bureau. We have a lot of interaction with them, with your facilities team and the state and local governments, and these are the things that tend to cross jurisdictions and deal with zoning and permitting, and so thank you for your time and coming here to address these folks today.
You're very welcome. So the wireless infrastructure notice of proposed rulemaking was released on September 26, 2013, and it seeks comment on 4 major issues regarding the regulation of wireless facilities siting and construction. And I guess we can advance the slide now. Thank you. So first, the notice seeks comment on measures to expedite the Commission's environmental and historic preservation review process under the National Environmental Policy Act and Section 106 of the National Historic Preservation Act in connection with the proposed deployments of small cells, distributed antenna systems, and other small-scale wireless technologies. These technologies, which can be deployed indoors or on short structures such as utility poles, may have minimal effects on the environment and historic properties. So the notice seeks comment on whether expediting or tailoring our review for these deployments would be appropriate, and on a number of possible options for doing so. Among these options, The notice seeks comment on whether to simply exclude these small facility deployments from review, and if so, how to define the facilities that would be subject to the exclusion. But the notice also seeks comment on narrower options that would expedite review for some of these deployments. For example, with regard to historic preservation review, the notice seeks comment on a possible modification of the current requirement that co-locations on non-tower structures that are over 45 years of age are subject to review on the basis of the age alone. And the notice seeks comment on whether we should provide that co-locations on structures such as utility poles will not be subject to Section 106 review based solely on the age of the pole. The second major issue in the rulemaking, and you can advance the slide if you want to. Thank you. Thanks. Second major issue in the rulemaking also addresses an aspect of the Commission's environmental process. Specifically, consistent with an interim waiver that the Commission adopted in May of 2013, the notice proposes to adopt a narrow exemption from the pre-construction environmental notification process for certain temporary towers. The notification process generally requires a 30-day period of public notice for proposed towers that require antenna structure registration. However, carriers often face a need to deploy temporary towers with very little advance warning, for example, in response to a disaster or other newsworthy event. So the notice tentatively finds that a proposed exemption will help ensure providers can meet these unanticipated short-term needs. Under the proposed exemption, eligible towers must meet specific criteria that should minimize the potential to cause significant environmental effects. And further, temporary towers that receive an exemption from our notification process would still be required to comply with our other rules for environmental review, including, for example, the obligation to certify environmental compliance and to file an environmental assessment in appropriate cases. The third major topic in the rulemaking addresses Section 6409A of the Middle Class Tax Relief and Job Creation Act of 2012. Under Section 6409A, Congress provided that a state or local government may not deny and shall approve any eligible facilities request for a modification of an existing wireless tower or base station that does not substantially change the physical dimensions of such tower or base station. And it further defined an eligible facilities request as including co-location, removal, or replacement of transmission equipment. It did not, however, define any of the other terms of the statute. So because most of the terms of the provision are undefined and the legislative history is fairly limited, the notice seeks comment on whether the Commission should adopt rules to clarify the requirements under the provision, and if so, how the provision should be interpreted. The notice seeks comment on how to define the various statutory terms, including what is covered by the terms wireless tower and base station, and how to define when a modification would constitute a substantial change in the physical dimensions of the tower or base station. It also seeks comment on whether the statutory language leaves any discretion to deny or condition approval of a covered request on whether the provision warrants establishment of time limits for review and on possible remedies in the event of a failure to approve a covered request. The notice further seeks comment on how to encourage ongoing efforts by local government and industry representatives to develop best practices for applying the section and on what role such best practices might play in the interpretation or implementation of the statutory provision. The fourth topic in the notice addresses certain questions or disputes that have arisen under the Commission's 2009 declaratory ruling, often called the shot clock order. which establish presumptively reasonable time periods for local review of wireless facility siting applications under Section 332C7 of the Communications Act. The notice also seeks comment on whether Section 332C7 limits local authority to establish preferences for siting facilities on municipal properties. So since the release of the notice, we've received comments and replies, and we're currently reviewing the record. While the comment period is now closed, parties may still make ex parte submissions to supplement the record either by written filing or through a meeting with Commission staff, and we would encourage you to do so. Thank you very much.
Thanks, Peter. We had a question come in via Twitter. Specifically, how are local cell tower permitting requirements being applied to small cells and DOS?
Well, one of the issues that we are raising under the shot clock order section of the item is how that particular provision and our declaratory ruling applies to DAS and small cells. So we know that in some cases, DAS and small cells are being reviewed by local governments under procedures consistent with the ruling, and other local governments are construing DAS and small cells as falling outside the scope of that provision. So that's one issue that we're looking at, and we may clear up in this proceeding.
Thanks. And in that regard, we'll welcome, I should say, ex partes from interested parties on that topic to
Absolutely.
help inform the record and help Peter and his team draft up something and come to their conclusion that they'll present to the chairman and the commissioners. Anybody else? I know I had some requests from state and local governments to be sure we had enough time for this section because you guys were going to have a lot of questions. So now's your opportunity to send them in. Oh, here comes one. Let's see. This comes from Mitzi Herrera here in Montgomery County. It's the same. Let me read. In the forthcoming modification order, will the FCC provide any means for consumers to submit information about dead spots? And will there be any tools to require wireless providers to address this issue? What steps will the FCC take to determine whether shot clocks are effective? The FCC adopted a shot clock for review of tower siting applications. Since adoption of that rule, what has been the rate of growth in new applications filed or applications approved? Has the Commission collected any of this type of data from wireless service providers? It is widely rumored that the FCC will adopt a shot clock to approve antenna modifications. What is the projected increase in the rate of growth of new applications filed or approved? Does the FCC have a target number of antennas, towers that they want to see newly sited or modified in the next 3 years? I think that's a lot of questions, and let's give Peter a couple of seconds to digest it, and I'm not sure that he's going to be able to answer all of those questions right off the bat. We may have to get back to you, Mitzi, offline on some of those, but to the extent Peter is able to answer any of these now, he will.
Okay.
I don't know.
I'll give it a shot.
Not to put you on the spot, Peter.
I think our data is actually pretty limited on approval rates and times and the impact of the shot clock ruling, although that's certainly one thing that we're interested in hearing about. As far as whether the FCC will provide any means for submission of information about dead spots and tools to require wireless providers to address that issue, that's really outside the scope of the proceeding that we're dealing with, which is about the regulation of siting more than it is about carriers' actual deployment. So that's probably not something we're going to address or talk about in this context. And I think as far as adopting a shot clock to approve antenna modifications, I think that is essentially what the 2009 declaratory ruling did. And in the notice of proposed rulemaking, we made fairly clear that we don't intend to revisit our 2009 decisions, although we are raising certain issues to clarify it. So I think our plan is that the 2009 declaratory ruling seems to be having at least some positive effect, and we intend to allow it to continue operating.
Thanks, Peter, and thanks, Mitzi, for the question in Montgomery County, Maryland. Anything else? Any other questions? Now's your opportunity. We're a little ahead of schedule, so I'm just going to ask Peter to hold on a second while you guys think of questions. Again, I know there were a lot of requests for a lot of time on this topic, so we'll give it another minute or so. And then if not, we'll move ahead to our break and resume at 3 o'clock. But if you want to go ahead and tweet those questions in or send them via live stream, we're here, and you have Peter's brain to pick. Okay. I think, we have one more comment. I think we have a few questions being tweeted in. My staff tells me here, and I'm going to... Okay, the Twitter questions are coming up. This is a good one. From Ken Fellman over in Colorado, and a good friend of NTOA. How much time do local governments have to do ex-parte meetings? When might we expect a decision? I don't know. To the extent Peter can answer that, he will.
Yeah, well, there isn't a definite time that we have for a decision, but I think right now it's likely that there's not going to be any action this summer, and I think probably not until late fall. So you have quite a bit of time to come in and submit ex partes.
Okay. From I can't tell where Mr. Fritz is from, but he asked, will the FCC allow those states and localities that have adopted their own definition of substantial change to keep their definition?
I think that, obviously the definition of substantial change is one of the big issues in the proceeding. We haven't come to any conclusions about it, including whether or not to address it, and if so, what the standard should be. That said, it's a federal requirement. If there's a federal standard, then that's going to be applicable to state and local governments under the provision.
Under the Telecommunications Act.
Under the Section 649A.
Let's see, we have one more coming in. It's the general sort of question. Could you address, based on comments filed and staff research, how much small cell installations may present any environmental concerns and negative impact on historic preservation? I think that's all.
Sorry, say that again?
Sure. could we address how under the comments filed in any of our own research, how small cell installations may present any environmental concerns and negative impact on historic preservation? Doesn't the process already, it takes that?
Well, I mean, that's one of the issues that we definitely have to look at, and it's pending in the proceeding. We haven't made any determinations as to whether or to what extent exclusions or tailoring is appropriate, and that's in part going to be based on conclusions with regard to whether and under what circumstances there are environmental concerns or concerns of adverse impacts on historic properties. We have to make those determinations before we can say anything about it.
Thanks. Yeah. Peter's politely saying we have to be careful not to prejudge the entire order of words, especially since we're having questions about more ex partes coming in additions to the record. Peter and his staff are certainly going to take everything into the record into account, and you could get your written ex partes into the record. It sounded like there'll be some more time to do so. So to the extent states and localities, municipalities, counties feel strongly about some of the issues, now's your time to get that into the record if you have not already done so. Okay. I think we're going to let Peter go from the hot seat, and if any other questions come in, I don't see anything coming in from Twitter, and there seems to be a lull. We'll get them to Peter and his team working on the facility side of WTP. Thank you so much, Peter. We really appreciate you being with us here today.
You're very welcome.
Thank you. Okay, so I think we are going to go to our break, and we're going to resume at 3 p.m. With the James Miller from the Office of Engineering and Technology talking about the new FCC Speed Test app to measure your actual broadband speed, and this will mostly be talking about wireless. And you could actually go ahead in the meantime and go to the iTunes Store or to the Google Play. It's available for Android and iTunes, and you could download that Speed Test app if you want and play around with it, and then you could send James any questions you have after his presentation. So I encourage you to download that app for your Android or iPhone now. Go ahead and test it out and pepper James with questions. And we're going to go to our break now. Thank you. Okay, welcome back to the second half of today's state and local government webinar at the FCC. Next up, we have James Miller, a senior attorney in the FCC's Office of Engineering and Technology. He's going to talk to you about our Speed Test app and the Measuring Broadband America program.
Thanks so much, Greg. And again, thanks very much for the opportunity to talk with everyone about the Measuring Broadband America program. We'll talk through some of the background, a little bit about the history that we have in the testing of fixed broadband performance, and then focus a little bit more attention, as Greg was mentioning, on our mobile broadband measurement efforts, our FCC Speed Test app. And I'd encourage you to download that from the Google Play Store or the Apple iTunes Store. As we're going through the talk, you can maybe get a feel for the interface, but going to your store now and typing FCC Speed Test should pop it right up. Hope you enjoy the presentation and playing with the app. So as we were saying, the Measuring Broadband America program, of course, came out of a recognition of the importance of broadband and the need to improve the availability of broadband network performance information for consumers and the public. We went through a very exhaustive review and analysis of broadband in the United States in our National Broadband Plan initiative. And out of that effort came a number of recommendations. One of them was, of course, to develop more information in this area, producing an open and transparent platform for measuring broadband performance and releasing the data around that. And we'll talk about how that program works. But the core principles of the program reflect that recommendation, and that we provide open and transparent processes and information on broadband performance. We release our collected data consistent with our privacy policy. And we work in collaboration with industry and academia and other stakeholders in the effort. Our fixed broadband tests started around 2011 as we started gathering data on fixed broadband technologies. We're talking about DSL and cable and fiber, as well as other options that consumers have available. And we've released 3 reports on fixed broadband performance over the last 3 years, and we're in the final stages of a final report for data collected in September of 2013. And the strategic goals for the program are to ensure the accountability and increased transparency and enhanced competition for the marketplace. We've seen that the reports have spurred investment. They've helped consumers make informed decisions about the marketplace and help the Commission make fact-based decisions. You'll also see us describing this effort as our data-driven efforts. We see this as a valuable part of that process. But we've developed an infrastructure for nationwide testing and data collection, and we'll talk a little bit more later about how that is a platform, and we'd like to see how that could be used for other collaborative efforts, especially with local and state and other municipality or other government efforts. We started the program, as I mentioned, measuring fixed broadband, and recognized the importance of the mobile broadband space and the need to expand the program to mobile broadband networks. We achieved that with our first release of the test app for Android in November of last year, and then again in February this year, our release of the iPhone app. And they share the same core principles and open methodologies of our fixed effort, in that we provide information to consumers and interested stakeholders using the same open and transparent methodologies, but focused on mobile broadband in this case. And of course, the release of the collected data consistent with our privacy policies. We encourage the same sort of improvements in the mobile broadband network and marketplace and drive competition and fact-based decision-making. And we utilize the same collaborative, open approach with support from academics and industry and government, public interest, and other stakeholders. So in that context, we've enjoyed the participation of major carriers, other government entities that are active in broadband and privacy-related matters, notable academic researchers and scientists in the area, as well as other manufacturers and other entities in industry and academia. And the fixed program that we had been doing for the period beginning in 2011 provided a lot of very important background for our efforts as we started to look at the mobile marketplace. One thing that we always have held in the highest to the highest concern was protecting consumers' privacies, and we began our efforts in 2012 in the fall with a focus on that in the mobile space, and began a process to develop policies and procedures working with a diverse set of privacy experts from the federal government, and academia, and industry, and came across a model that was fully anonymous data collection with no personal or identifiable information that's collected. We also release our client software as open source, and this provides an opportunity for third parties to inspect it and understand the workings of the software. Our analysis of the data and the statistical properties are reviewed by privacy experts as a secondary check to ensure that the anonymity of the data is preserved, and address any concerns around re-identification prior to the release of data. And here we're talking about large data sets and the patterns that are exposed in those data sets. Our mobile app terms and conditions and the privacy policy were developed over a multi-month process. We didn't call it a privacy by design, but you'll see that buzzword sometimes in the marketplace. And out of that came across a privacy approach that avoided any direct personally identifiable information, but also took attention to the unique handset identifiers or other sorts of data features, and a secondary check analyzing the data that we would collect and processing against any sorts of risks of re-identifying particular handsets. So looking at the functionality of the app, you'll see that the tests run a series of upload and download, a UDP-based latency and packet loss test, and also gathers information about the mobile cellular interface, things like the received signal strength, what the bearer channel is, whether it's 4G or 3G, what sort of technology is used, what the carrier is, what the cell tower ID is, and other sorts of information that may be helpful to understand the broadband performance. In the context of our collaborative process, we also received a great deal of very helpful feedback about how we can improve not just the interface, but also the functionality of our client application to address concerns that consumers might have, such as data caps. So we have a default that limits the amount of data that the scheduled tests will use to 100 megabytes. For a lot of consumers with an unlimited plan or higher plans, they can configure and configure the app for higher data caps so that they can run more tests and get more information about their broadband performance. But that's an example of things that we looked at. How, battery usage and other things are also sort of addressed in the consumer's application interface. One of the benefits of a highly anonymized and robust sort of identification perspective is that when the data is collected, it's collected in a form that is very low risk from the perspective of protecting a consumer's privacy. But we still have a real need to understand what our own performance is. And so from the user's perspective, when they run tests or the tests are running in the background, that information is stored on the handset and then displayed in the application. And if you're running a lot of tests or you've been running it over a week or a series of months, you can scroll through those results and see what your broadband performance is for download and upload and other performance right on your device. So you'll always know what your performance is, but we collect the data in a way that still preserves that balance for consumer privacy. When it goes out to the cloud, you wouldn't be able to identify your particular information in the set of data that's collected, for example. The software and data tools have been designed to support big data. And of course, we hear this a lot. It's confusing for some of us, but the gist of the discussion is the format that the data is stored in is very accessible for people doing large data analysis. The results are stored in what we call a JSON file format. We have conversion tools for other sorts of data processing sorts of environments. CSV is something you may be familiar with. And we document the data dictionaries and schemas, so if you are interested in looking at the data, there are tools available to make that process much easier. The data sets are released freely and openly, subject to our privacy policies, and are documented as we discussed with the data dictionary and the structure of the exports defined. And it's also, of course, anonymous data that's been subjected to a secondary review to ensure that consumer privacy is protected. So the data sets that we will make available, we think will have a lot of value for consumers and the public, and offer a lot of opportunities for collaboration. One thing that we've focused on also is how to represent the data for consumers in a way that's useful. And we plan to release a series of interactive tools and open data sets sometime this year, including maps of broadband performance that will show information at different sorts of geographies, comparing technology to help consumers inform decisions about things like what sort of handsets they might be interested in, other tools and reports based on recommendations from consumers, public interest groups, or other stakeholders, as well as aggregated statistics and tables and data sets vetted against the FCC's privacy policies for mobile data. a look at maybe things to come, we can see we've released a couple early markups of ideas around the time of our first release, and expect that these technologies will share the same sort of DNA as our program in general, based on open source and supporting open and transparent methodologies. But we think that this will also be a really valuable tool for consumers to understand not just how their data and performance results look, but also how the total market, what the look of consumer broadband performance looks like from the U.S. perspective. So our program goals, of course, were to create a national database on mobile broadband performance and characteristics that are accessible without restriction to the public, but also to protect privacy and maintain consumers' confidence in the program, and to advocate for standardized metrics and data formats. We promote the sharing of technologies and information with similar programs, and we do this by disclosing how we measure things, what the architecture looks like, describing these open methodologies, by releasing our data sets in ways that promote collaboration and sharing, and of course using technology that is open and supports collaboration. We release our software as open source and have a very strong commitment to collaborating with all interested stakeholders. So we think this offers a lot of opportunities for collaboration. If you're trying to answer questions about broadband performance in your area, there's oftentimes a set of tools that you can turn to. We're very excited to be able to offer shared data sets for folks to make use of. Our source code is available, and this may offer opportunities for folks to pick up the work that we've done and extend it or tune it for particular purposes. And we could see opportunities where folks might be able to support state data collections, either using the platform or in cooperation with the platform. And in general, leverage the collaborative and privacy-centric best practices that we've developed as part of the program. So with that, maybe we'll pause and offer some time for some questions.
Thanks, James. That was really helpful. Let me try taking a stab at a few questions. What does this mean for the town, county, or state chief information officer or the local government as a purchaser of broadband services?
Well, as a purchaser, we all want to get the best value for our dollar, and understanding what sort of technologies are available, what sort of performance is actually available in the areas that we need it. Those are all things that we can find tools for, and I think increasing the amount of information available and the quality of information available helps us make better decisions when we make those sorts of purchasing sorts of
find out
efforts.
Find out if you're really getting what you're paying for.
Exactly. So of course we can look at the data directly. We'll have tools available for maps and things like that for folks that want to look at things at a high level. And then the other consideration, of course, is while we're in government, obviously big purchasers of technology, we're also in a position to advise other people or recommend strategies, and broadband is critical to local development. If you're thinking about local tax policies or how to promote investment in your area, the impact of residential and home buying, for example, all these things today are looking to broadband as an element that they consider. So what's your broadband performance in your town, in your county, in your locality? That's an important thing to know.
And you could provide that to the company that's interested as a economic incentive,
right?
An incentive. Okay.
And I think one thing to sort of note is that we've had some experience with the fixed program over the last 4 years, which is a little different from our mobile approach. In that environment, we have dedicated hardware probes that are sent out to volunteers, and then their consumer broadband performance for their fixed services tested using that box. The mobile app is great because if you've got an ongoing outreach effort, if you've got some flyers at the local city hall, for example, you could make that information available to your constituents. When they download that app, they'll be directly contributing to the information that's part of our national database. And the more folks that download the app, the better the information will be, and the more information we can make available. So there's a lot of synergies that I think we could talk through about working together.
Great. Thank you very much. I don't see any questions coming in anymore on the Measuring Broadband America or the FCC Speed Test app. We do encourage you to go to the iTunes Store on Google Play and go ahead and download that on your local government or state government's wireless devices, and that way you could get a better map of what's happening in your area in terms of actual broadband speeds. And then that's all crowdsourced and it's open data, and you can provide that as an incentive to help grow business or do what you need to do in your community. So thank you.
Absolutely. Thanks, Rick.
Great. Next up is Dana Zellman. She's an attorney in the Public Safety and Homeland Security Bureau, and she's going to be speaking to us about the very important topic of Next Generation 911, or Text to 911, which is a part of that. And I know this is something that is on every municipality's mind, and state as well, state police. Okay, thanks.
Good afternoon, everyone. My name is Dana Zellman, and I'm an attorney advisor in the Policy Division of the Public Safety and Homeland Security Bureau. Hold on one second. We're going to get there. We go. Anyway, today I'm going to talk a little bit about the Commission's efforts for Next Generation 911 and some considerations for state and local governments as you develop near and long-term plans and budgets for 911 service in your area. So you might be asking yourself, why NG 911? I'll begin by noting some significant changes in consumer behavior which suggest the need to update existing 911 networks. So for example, there's been increased adoption of smartphones and the usage of text messaging. 91% of Americans own cell phones, and 81% of those cell phone owners utilize text messaging. There's been an increase in the number of wireless-only households, which is roughly 40% of American homes no longer have a landline. And there's also been an increase in the number of wireless calls to 911. And in some jurisdictions, it's 70 or more % of all 911 calls. So Next Generation 911 will enhance and expand access to emergency services. It will serve all constituencies, including the 15% of the U.S. population that is deaf, hard of hearing, or has a speech disability, 85% of which use text to communicate. It'll provide a means of seeking emergency help in dangerous situations like an active shooter scenario, network congestion, or other moments of inadequate voice coverage. And Next Generation 911 will also provide enhanced data and situational awareness for first responders. While Next Generation 911 offers promise to expand access to 911 networks for everyone, there is still substantial work remaining. Some things to consider. The NG 911 evolution is a work in progress with many technical, operational, financial, and governance challenges to be addressed. Many communications networks that support public access to 911 are already transitioning to IP, and many major communications providers ultimately intend to decommission their legacy TDM networks. Some state and local 911 authorities have taken steps towards NG 911, but most PSAPs remain heavily reliant on legacy network elements. We at the Commission have taken actions that recognize short-term needs like interim text to 911, as well as longer-term goals and requirements like our recommendations to Congress and our annual funding report. The next generation transition will take time, and it will not be uniform nationwide. Nevertheless, some state and local jurisdictions have already incorporated NG 911 elements into their 911 systems, and they serve as important laboratories for identifying and evaluating technical, operational, and security issues that may arise during the rollout of NG 911. For example, some jurisdictions in California, Colorado, Georgia, Illinois, Indiana, Iowa, Maine, Maryland, Montana, New York, North Carolina, Ohio, Pennsylvania, South Carolina, Texas, Vermont, and Virginia have already implemented text to 911 for certain jurisdictions in their states. Furthermore, some jurisdictions are developing, testing, and bringing online emergency services IP networks, or EZNets, which will deliver voice, video, text, and data calls to a PSAP. These early adopting jurisdictions can be valuable informational resources to state and local governments that are considering adopting NG 911 elements in the near future. The Commission has also posted links to several early adopters' websites on its PSAP Best Practices page, which I will touch on later. Again, though progress is being made, considerable work remains before the full realization of Next Generation 911. The Commission has identified 5 core elements that must be in place before the nation's 911 networks will be fully transitioned and considered to be next generation. These elements include enhanced consumer and PSAP capabilities to support the delivery and use of multimedia information. And that refers to voice, text, data, photos, and videos that could be sent to the PSAP and used by the PSAP. It also includes effective location accuracy determination for all NG 911 applications. We also need comprehensive and consistent technical standards to ensure the functionality, interoperability, and security of all system elements. We need adequate and sustainable funding for NG 911, and we also need a workable framework for NG 911 governance. As a first step in providing consumers and PSAPs with the capability to support the delivery and use of multimedia information, in January, the Commission adopted a policy statement and second notice of proposed rulemaking on text to 911. The policy statement made clear that the Commission believes that every CMRS carrier and every text messaging provider that enables a consumer to send text messages using numbers from the North American Numbering Plan should eventually support text to 911. It also clarified that the Commission intends to take a technologically neutral approach to any rules adopted for text to 911 service, and that the Commission encourages voluntary agreements to support this capability, which would eliminate the need for the Commission to adopt rules for text to 911 in the near future. The second notice of proposed rulemaking sought comment on several near and long-term technical issues for both CMRS and interconnected text providers, including roaming and how to provide location information with SMS. Comments in response to the notice of proposed rulemaking were due on April 4th, but the reply comment window extends through May 5th, and we welcome your feedback on the issues outlined in the item. We also note that pursuant to an agreement struck in December 2012, the 4 major wireless carriers, AT&T, Sprint, T-Mobile, and Verizon Wireless, have agreed to make text to 911 available to requesting PSAPs by May 15th, 2014. As I mentioned earlier, a number of jurisdictions have already requested and deployed text to 911 service with the help of these carriers, and we hope to see that number grow after May 15th. Some smaller carriers have also informed the Commission that they are developing their own voluntary agreements to help support text to 911 nationwide. With regard to PSAPs making requests for and implementing text to 911 service, the Commission has posted a web page with information on best practices. Furthermore, the Communications Security, Reliability, and Interoperability Council, or CISRIC, will be issuing a report in June of this year that will describe in greater detail best practices for PSAPs requesting text to 911 service in their jurisdiction. The second critical NG 911 element the Commission has focused on is the location accuracy of 911 calls. In February, the Commission released a third further notice of proposed rulemaking, which sought comment on a number of proposed regulations. It proposed some indoor requirements, which would have wireless carriers providing location accuracy in both the horizontal and vertical dimensions. Compliance with the regulations was proposed to be demonstrated through a testbed mechanism, although compliance would ultimately be measured at a county or PSAP level, similar to existing E911 rules. The notice of proposed rulemaking also proposed that enforcement through the Commission would require that PSAPs have implemented bid and rebid policies before they can seek enforcement. The Commission also sought comment on how stakeholders could leverage commercial location-based services for 911 location accuracy, as well as how to achieve its ultimate goal of obtaining a dispatchable address for each wireless 911 call. Comments in response to this rulemaking are due May 12th, and reply comments are due June 11th. The third core element of NG 911 is the development and implementation of consistent standards. This will first require development of standards for a 911 environment that operates using Internet Protocol. Transition to an all-IP world will impact all emergency communications and will serve as a foundation to enabling other NG 911 functions, like the submission of video or photos to a PSAP or the consolidation of PSAP services within a region or state. In addition to IP-based standards for NG 911, other technical and operational standards will need to be developed, as well as cybersecurity standards for the defense of NG 911 networks. In January, the Commission issued an order which called for experiments that would simulate how public safety communications would operate in an all-IP environment. These experiments will begin this year, spearheaded by AT&T. On a related note, the Commission recently held a workshop on April 17th and 18th that discussed how, both during and after the IP transition, public safety entities would address everyday incident response, disaster preparedness and response, and how it would address cyber risks to commercial, public, and government networks. Lessons from the workshop and the trials will be helpful as we move forward towards NG 911. With regard to standards for other NG 911 elements, CISRIC 4 Working Group 1 is currently assessing best practices for PSAP requests for text to 911 service, the mechanics of the proposed indoor location testbed, and the feasibility of using a joint ATIS TIA standard for text to provide Phase 2 location determination. Their reports are expected for June of this year. I also want to emphasize that NENA has put out guidelines and has published a standard called I3 that works as a blueprint for basic NG 911 architecture. And their documents would be very helpful as people develop their plans to move towards NG 911. NG 911 also brings up an issue that many local PSAPs have not previously had to consider: cybersecurity. In an all-IP world, cyber events present a risk to PSAP operations that cannot be ignored. The Commission therefore encourages state and local governments and PSAPs to consider the cybersecurity framework set forth by the National Institute of Standards and Technology. This framework provides an adaptable and easily used method to systematically evaluate cybersecurity risks, to protect assets from cyber risks, and to recover from cyber events. The framework was initially developed for private companies, but it can be scaled to address the needs of PSAPs both large and small. We encourage everyone to develop a plan for protecting against and responding to cyber events, and the cybersecurity framework outlines reasonable steps that every entity can take to address these risks. One of the most pressing issues with Next Generation 911 is how it will be funded. Funding for 911 and NG 911 is left to state and local government discretion, and the Commission recognizes that many public safety groups face significant budget constraints, which will likely continue for some time. The Commission issues a report each year on fees collected for 911 purposes, and the fifth and most recent report, issued in December of last year, highlighted some of the disparities between state spending. Estimates of funds collected ranged from just over $2 million by the state of Nevada to a high of $212 million by the state of Texas. We understand that setting aside money for next generation systems is a hard thing to do when so many other day-to-day operations need funding as well. But we encourage the investment towards NG 911 as it will provide public safety with a necessary pathway towards utilizing future communications. Another significant factor Another significant factor in the successful rollout of NG 911 is proper governance. Public safety regulation, like funding, is generally reserved to the states, but the Commission has looked into how governance will impact the transition to and realization of Next Generation 911. The Next Generation 911 Advancement Act of 2012 directed the Commission to submit a report to Congress containing recommendations for the legal and statutory framework for NG 911 services. The Commission issued its report to Congress on February 22, 2013. This report contained recommendations for a legal and regulatory framework for the development of NG 911 services and the transition from Legacy 911 to NG 911. It contained recommendations for legal mechanisms that would ensure efficient and accurate transmission of 911 caller information to emergency responders. And it recommended how to remove jurisdictional barriers and other inconsistent legacy regulations. We encourage state and local governments to read this report for guidance on Next Generation 911 governance. While governance is primarily handled on the state level, NG 911 governance also includes some federal components, one of which is the regulation of how wireless carriers respond during extreme weather and other natural disasters. The Commission has noted a clear need for governance in this area. Hurricanes Sandy and Isaac resulted in the outage of wireless service for more than 25% and 20% of cell sites, respectively, in designated coverage areas. As I said earlier, Americans are increasingly cutting the cord and relying exclusively on mobile wireless networks to communicate. 38% of these households in the United States do not have a landline, and a majority of 911 calls originate from wireless phones. Overall, mobile wireless networks do not perform adequately during major disasters, though some do better than others. And the public has no means of comparing how each wireless provider withstands and recovers from major storms or disaster conditions. Finally, providers really don't have incentives to compete on the basis of resiliency during these disasters, and we want to change that. The Commission first addressed 911 transparency in September of 2013 when it issued a notice of proposed rulemaking on wireless providers' accountability to local public safety agencies during major storms. This proceeding proposed to require wireless service providers to report to the FCC on a daily basis during and immediately after disasters the percentage of operational cell sites for each county within a designated area. It proposed rules that would enable consumers to compare providers' wireless performance in emergencies and hopefully encourage competition in the wireless industry for resiliency purposes. This item also sought comment on alternative measures that could improve wireless network resiliency, like alternative forms of disclosure, backup power, or other mandatory performance standards. The comment window for this proceeding closed on February 18th of this year. Consumer groups like consumers unions very much supported the proposed reporting and disclosures, while carriers strongly opposed them. A related governance topic to 911 transparency is 911 reliability. In December of 2013, the Commission released an order requiring covered service providers to take reasonable measures to provide reliable 911 service. Specifically, the order required covered 911 service providers to demonstrate compliance annually with this reasonable measures obligation by implementing industry best practices as specified in the rules or implement otherwise reasonable alternative measures. The order also required covered 911 service providers to provide initial notification and contact information to affected PSAPs within 30 minutes of discovering an outage that potentially affects that PSAP, and then to follow up with additional material as it becomes available, though no later than 2 hours after the initial contact, with information on the nature of the outage, its best known cause, the geographical scope of the outage, and estimated time for repairs. Finally, this order provided PSAPs with an ability to contact the FCC if it believes it is not receiving proper notification from a 911 service provider. They can inform the FCC at www.fcc.gov/document/PSAP PSAP outage reporting, and there's a link on this presentation if you can't see. While considerable work remains on the transition to NG911, progress has been made. A few things on the horizon for Next Generation 911. Like I said, the technology transitions proceeding and trials were launched earlier this year and will continue for some time, and we hope to get some really good information on throughout the year on those two things. The Commission has continued to be engaged with other NG911 stakeholders like federal entities, state, local, and tribal entities, the wireless industry, as well as consumer groups, and we will continue to provide web resources for state and local governments to help with this transition. On May 15th, a deadline occurs for the 4 major wireless carriers to provide text to 911 service for requesting PSAPs. And then we have 2 approaching comment deadlines, and we really welcome your feedback on these 2 topics. As I said, the reply comment window for text to 911 closes on May 5th, although the comment deadline has already passed. And then for the location accuracy proceeding, we have a comment deadline on May 12th, and reply comments are due June 11th. Next Generation 911 will require coordination on the local, state, and federal level, and it will certainly take some time. But it will provide the public and public safety entities with the communication tools they need to move emergency response and 911 networks into the 21st century. We at the Commission stand ready to help the public safety community to achieve its goals and to improve 911 communications for everyone. So, with that, thank you for your time, and I think we can open it up for some questions.
Thank you very much, Dana. That was very informative, and I'd like to stress again that Dana's presentation, along with the others, will go up on the website either later today or tomorrow. I know that was a pretty detailed presentation, and it'll be very helpful to a lot of folks. So thank you. I'm sure we may have a few questions from our friends in state and local government, or something coming in over Twitter. If not, we'll just we'll ask. Just ask you to hold on a second, okay, and sure. Please. We'll see. Or I'll tell you, if people think of some questions that they have later, they could either send them to myself, gregory.vatis@fcc.gov, or during the live stream, we have one more presentation. Send the email to the live stream email, and we'll be sure that Dana and her team get them and get back to you offline. Sure. So thanks, Dana. We really appreciate it.
Great.
Thanks. Okay. Our next speaker is going to be Karen Pelt-Strauss. She's a Deputy Bureau Chief in the Consumer and Governmental Affairs Bureau, and Karen's going to be speaking to you about closed captioning, and we expect her shortly. So why don't we take a couple of minute break, and as soon as Karen joins us, we'll be back. Okay? Thanks. Tuned with us. We're very lucky today to have Karen Pelt-Strauss, Deputy Bureau Chief in the Consumer and Governmental Affairs Bureau, who does all things disabilities for the FCC. And today, Karen's going to talk about the Commission's efforts on closed captioning.
Hi, it's so nice to be here. I'm very excited to be sharing this information with you. I was just introduced. I'm going to be giving you an overview of some new rules that the Commission just adopted that we're very excited about. Just to give you a little bit of background first, many of you probably know that we already have closed captioning rules requiring 100% of all new non-exempt television programming to be captioned, as well as 75% of older programming that's first shown before January of 1998. That must be captioned. Those rules went into effect back in 1997. It applies to both English and Spanish programming, as well as bilingual English/Spanish programming. There are some exemptions, for example, some overnight programming that is shown between 2 and 6 a.m. local time, advertisements that are under 5 minutes, public service announcements under 10 minutes, channels producing revenues under $3 million, music without lyrics, and no provider needs to spend more than 2% of its annual revenues on captioning. Those rules, as I mentioned, have already been in effect, and just this February we updated our captioning rules. I realize this is not necessarily pertinent to state and local governments every day. However, you should be interested in our rules because some of you do have television stations and or provide information or hearings on your local business, your local governmental business on television. And so you too would be subject to these rules. So the new rules that we adopted set standards for quality. We never had quality standards before. In the past, when the Commission adopted the initial rules, it said that it was hoping that the marketplace would address quality standards, but in fact that has not happened. And so many years later, we now come and revisit this. There are 4 quality standards. They are accuracy, synchronicity, program completeness, and placement. And very briefly, accuracy is just what it says. It reflects the captions must reflect the dialogue and other sounds and music in the audio track to the fullest extent possible based on the type of programming, and must identify speakers so that, for example, if a speaker is off screen, you have to indicate that. Synchronicity means that the captions have to be timed with the corresponding audio. So in other words, they shouldn't be way ahead of the audio and they shouldn't be lagging too far behind. They shouldn't be too fast that they can't be read by viewers as well. Program completeness means that captions should be complete from the start of the program to the end of the program, meaning that they shouldn't just drop off in the middle of the program. And placement means that captions should be appropriately placed on the screen so that they are not blocking any character faces or other text or other important information that's essential to the understanding or accessing of a program's content. Depending on the type of programming, these rules will apply differently. So for pre-recorded programming, we're pretty much expecting full compliance with all 4 components. But we understand that because live programming uses real-time captioning, which means the captions are produced as the programs are provided or aired, we will consider the challenges such as a lack of an opportunity to review and edit the captions in advance. But we still expect the captions to be, even on live programming, accurate, synchronous, complete, and appropriately placed, at least to the extent that it will allow viewers to understand the program and have a viewing experience that's comparable to somebody listening to the soundtrack. Near live programming, we're treating the same way as live programming. We're defining near live programming as programs that are performed and recorded within 24 hours prior to when they're first shown on television. In addition to the 4 standards, our new rules contain best practices. These are practices that were given to us by members of the industry, the television industry, and programming industry. And an entity can follow these best practices in lieu of following our rules on standards exactly. So the best practices really focus more on procedures, and if you follow the best practices, you're deemed in compliance with our standards rules. An example is there are requirements in the rules that captioning, that agreements between captioning vendors and programmers, video programmers, include performance requirements for high-quality captions, such as requirements for error-free captions that are punctuated correctly, placed properly, and synchronized. Another best practices is having performance evaluations of captioners. Another one is screening, training, and supervising captioners. And another one is ensuring that there are technical system functionalities, for example, that the telephone lines and IP transmissions are working properly. A consumer that wants to file a complaint against us, or against a programming provider, or rather distributor, can do so. We are specifying what consumers have to produce in their complaint for it to be served on an entity. We want the complaint to be specific enough so that it's not a fishing expedition for the entity that has been charged as having violated the rules. So we're asking for things like the channel number and name, call sign, the name of the MVPD, which is a multi-video programming distributor, the date and time when the captioning problem occurred, the name of the program, and a detailed description about what the captioning problem was. Our rules also cover news programs. News programs right now, local news must show their programs with captions. However, they are allowed to use, most of the stations are allowed to use something called electronic newsroom technique, which uses teleprompters to caption, but often those teleprompters miss live sports, weather, and most late-breaking news. The only stations or networks that are required to have real-time captioning right now are the major national broadcast television networks, including ABC, Fox, CBS, and NBC, as well as affiliates of these networks in the top 25 television markets and national non-broadcast networks serving at least 50% of all homes subscribing to multi-channel video programming services. So we've had a problem over the many years because consumers who rely on captions have complained that all the other local newscasts that are using ENT are not providing them with the level of access that they need to understand the news, that there's been too many gaps. So our new rules say that you can keep on using ENT if you're allowed to under our rules. We're not changing who's allowed to provide ENT, and we're saying that if you were required to provide real-time captioning before for local news, you're still required to do so. But if you can use ENT under our rules, you have to make sure that the ENT that you provide has captioning coverage of most of the news programming you're showing, including captions on sports, weather, and late-breaking news. If you can't pre-script in the teleprompter field reports and other last-minute news items, you have to use crawls or other visual information. What we learned in this process was that, in fact, almost everything now is scripted as compared to when we first adopted our rules back in 1997. So given that there's a whole lot more that's scripted, and even on the scene news reporting, a lot of it is scripted. People will go on the scene, reporters will go on the scene and type up what they're going to be saying and then send it back to the station. We think that this rule is possible. We're going to assess the effectiveness of these new requirements and whether or not we still need to move to real-time captioning for all news programs after 1 year. But we're already working very closely with the National Association of Broadcasters and other industry groups to make sure that this works. So there are some other captioning matters that we addressed in these rules as well. The rules that I just talked about, the standards, we call non-technical quality standards. Those are the standards for timing and accuracy, etc. But there's also a technical component to providing captions effectively and intact to end users. And that's basically a requirement that video distributors monitor and maintain their equipment, their transmission equipment and their captioning equipment, and to take any corrective measures necessary to ensure that such equipment is in proper working order as part of their obligation to ensure that the captioning included with their video programming reaches consumers. We had this requirement before in 1997, but we hadn't codified it. That meant that we had it in our order on the captioning rules, but it wasn't actually in the rules themselves. Now it's in the rules. We also just added a new requirement for video distributors to perform routine technical equipment checks in a manner that's sufficient to ensure that captions are passed through to viewers intact. And we finally added a new requirement for distributors to keep records for at least 2 years of their activities related to the maintenance, monitoring, and routine technical checks of their captioning equipment. We also issued a declaratory ruling with our new rules, just to clarify certain things in that we've been asked questions about over many years. One of these is whether or not bilingual Spanish-English programming is covered. It is. So again, 100% for new programming, 75% for pre-rule. That's pre-1998 programming. That's bilingual. Bilingual, only English and Spanish, that's the only other language we cover, must be closed captions. If, however, there are small discrete portions of English or Spanish segments that are only a very small percentage of a programming that's otherwise not English or not Spanish, it need not be captioned. We are also clarified that all distributors are required to make their contact information available to consumers and the Commission, even if they aren't squarely covered by our captioning rules. Which means that they don't have to provide original programming with captions. Whenever a program on television is shown with captions, if it's shown by another video distributor and it already had captions on the first network, it has to be re-shown with captions. So technically all video distributors are covered to some extent under our captioning rules, and so they have to provide us with contact information. That contact information is used for the most part for handling complaints. We don't have other reporting obligations other than the ones I just mentioned. Also, on-demand programming, video on-demand programming must comply with our captioning rules, all of the ones I just mentioned, and low-power television stations must also comply with the rules. Attached to our report and order, we have a further notice. We're seeking comment on a lot of different things. Probably the most major is whether or not to extend some of our responsibilities for compliance with the captioning rules to other entities that have not been responsible to date. Our rules right now require captioning obligations to fall on video programming distributors, that's cable companies, national networks, etc., satellite companies. However, the captioning quality rules, many entities that came and talked to us while we were drafting these told us that the entities that are more effectively involved in ensuring captioning quality are the video programmers and the producers and the owners. And so what we're asking now is whether we should be imposing some responsibility or responsibilities for compliance with these quality rules on video programmers or other entities. We're also asking whether or not we should adopt specific measures to ensure program completeness and synchronicity for live and near live programming. I mentioned that we kind of have a little bit of a relaxed standard for live and near live programming because we understand that it's much harder to get pure accuracy. But we've been told that there are things that programmers and distributors can do to improve captioning on live programming. So in the further notice, the FNPRM, we're asking whether we should be requiring some of these things, such as providing advanced delivery of the audio track. Sometimes that's available, especially with near live programming, or fading out. For example, for synchronicity and program completeness, we're told that a lot of times the very last few seconds of a program misses the captions because on live programming there's a little bit of a delay. So should there be a fade out to add a few? It says a few seconds. It should be a few seconds before the next program. Should captions remaining at the end of a program audio continue during an advertisement and, for example, be put at the top of the advertisement while the advertisement's captions go at the bottom? For a near live program, should they provide a complete program script, or should they somehow give advance information to the captioning agency? In other words, should the programmer give some information to the captioning agency in advance of the airing so that they could start preparing, like vocabulary? Or should they give access to the live feed? So, for example, for late night programming, the live feed occurs at around 6 o'clock in the evening. Should a captioning agency have access to that so they could start doing the captioning at the time of the taping? We also ask how to define near live programming. I mentioned before that Right now, what we're defining it as programming that was prepared and aired at least, or prepared 24 hours before airing. Some people have said that that's too long, that we should shorten it to maybe 12 hours, so we're asking about that. We're asking whether to require offline captioning, that's captioning prepared in advance for the re-airing of live and near live programming. So let's say a live program like an awards show is shown with captions. If it's re-shown after that, should there be care to edit it and review it and edit it to make it better? That would be like offline captioning. We're asking whether or not we should have reporting obligations or some way of reporting obligations to us and some way of communicating to viewers if there are captioning outages, such as, for example, scrolls along the bottom of the screen, so that people who are watching television and stop getting their captions have an understanding of why their captions have stopped. And we're asking as well whether the Commission should modify or eliminate other exemptions that we have to our rules. One of the exemptions is that we have a 4-year exemption for any new network. So anytime a new network starts up, it has 4 years without any requirements for captioning. And the reason that was put into place was because the theory was that starting up is not an easy thing to do, and we didn't want to overburden startups. However, what we have found is that some of these startups are very wealthy, and so should this no new network requirement apply to everybody, or should it be financially based? We also, this was adopted at a time, the captioning in 1997 was fairly new to a lot of networks. Now that captioning truly has become mainstream, should we just eliminate the new network exemption and say, once you come online, once you enter the television experience, captioning is a part of what you have to do. We also ask about overnight programs, commercials, etc. Finally, we ask about some new technologies. 3D is not that new anymore. This proceeding we started writing about, probably 7 years ago. At the time we wrote it, it was a newer technology, but there are issues with captioning on 3D. For example, where to put the captions, what depth to put the captions. And we also are concerned that some people are unable to use our caption display, the requirements for caption display features. Caption display features were adopted by the Commission in the year 2000. It allows people to adjust the font, size, foreground and background color and opacity and a few other details about how captions are displayed. But being able to figure out on your television set how to access, or for that matter a computer, how to access these display features is not an easy thing to do. So we are exploring whether we can make this easier for consumers. And that concludes my presentation. I have here just some additional links that you might be interested in relation to the CVAA, which is the 21st Century Communications and Video Accessibility Act. Many of you are familiar with that. It's an act to bring many of the rules that we've adopted here at the Commission over the last several decades into the 21st century. One thing you should know about the CVAA is it does require that all television programs with captions to still contain those captions when shown on the internet. Now that the captioning quality rules will be going into effect, they'll be going into effect next January, it will require that the quality on IP caption programs that have been shown on television be at least as good as the quality had been on television. So it affects IP captioning as well. And there's a link there to our first biennial CVAA report to Congress, which just has a lot of information you might need, and that's my contact information. So thank you very much for giving me the opportunity to share this information with you, and are we able to take questions?
We absolutely are. So please, now's your time to send some questions in via email or Twitter. Really, we're very lucky to have Karen with us today. She is one of the country's leading experts on disability rights and communications issues. So we're really lucky that she took some time out of her busy day. And Karen's a great advocate for the disabilities community.
Thank you.
I don't, seems to be all quiet out there. That's what happens with these webinars, but I know usually when we go back and view the data, we have hundreds of online participants. So if you think of your question later or you don't want to ask it now, you could send it either to Karen. Her email's up, karen.strauss@fcc.gov, or send it to myself, gregory.vatis@fcc.gov, and we'll get back to you offline.
Sounds perfect.
Thank you so much, Karen. We appreciate your time.
No problem. Thank you.
Okay, thank you everybody for joining us today. You could always reach out to our Office of Intergovernmental Affairs through myself, gregory.vatis@fcc.gov, or give me a call. All my contact information is up on the web. And we'll try to get you help and answers with any questions, concerns, issues you're having with regard to anything we do here at the FCC. So thank you again. Oh, do we have, wait, oh, maybe too soon. Hang on. Oh, okay. I'll read it out loud. As Karen, whoop, we're too quick. Okay.
I'm still here.
Karen's still here. Thanks. Okay.
So should I answer?
Oh, go ahead.
Okay, so I can read the question. It asks when we are expected to have a fact sheet available for the new closed captioning rules. We have actually issued a very brief summary. Actually, two answers to this question. First of all, we have issued a very, very brief summary over access info, and I'm actually glad you asked this question because this gives me an opportunity to plug Access Info. This is an online or an email service that we provide wherein we send out periodic updates on our activities, our rulemakings, our conferences, and other events. Anybody that wants to get ongoing information from us, we try not to overwhelm you. We just send that information whenever we release something. Send an email to accessinfo, ACCESSINFO @fcc.gov, and just ask to subscribe either in the subject line or in the message line. But I believe that we actually do have a fact sheet available online. I will try to get that to Greg, and he can get it to you. I know that it needs to be done a little bit more comprehensively than it is now, but it does have the basics. And then the second question is, what is the timing for the Commission to act on the CVAA FNPRM? Cable operators are not making local PEG program and accessibility information available on electronic program guides in the same manner that similar information is made available for commercial and regional programming. There are members of the disability community who would like to have ex parte meetings to discuss how this affects their ability to find and access local community programming. The Media Bureau is the lead bureau on this FNPRM, and I'm sure that and I can tell you that we in CGB would be happy to have ex parte meetings with you. So feel free to contact us, and we would love to hear from you on this issue.
Okay, thanks. Anything else coming in via Twitter? No? Okay, so I think that's a wrap, and thank you again for that question, and feel free to contact Karen or myself, and we're happy to help you. Okay, and thanks for tuning in to today's the 6th State and Local Government webinar, and we hope we're picking topics that are of interest to you, answering your questions. Any feedback you want to give us is more than welcome. We always aim to improve, so thank you.